Welcome, everybody, for the next session of our fall symposium titled Impeachment and its Implications for the Separation of Powers. Last February, the U.S. House of Representatives voted to impeach Homeland Security Secretary Alejandro Mayorkas for high crimes and misdemeanors. Chairman Mark Green of the Committee on Homeland Security stated that, quote, Congress has taken decisive action to defend our constitutional order and hold accountable a public official who has violated his oath of office. But not everyone, including Majority Senate Democrats, agreed with that view. As such, we're excited to host Mr. Trevor Whetstone to discuss the question, was the impeachment of Secretary Alejandro Mayorkas constitutional? We originally had planned to host Mr. Joshua Matz as well, but he unfortunately had to cancel due to a family emergency. We all wish him well. I'm now glad to introduce Mr. Whetstone, and I'm very much excited for this conversation. Bring good questions. Mr. Whetstone serves as General Counsel for the U.S. House Committee on Homeland Security. Prior to this role, he served as the committee's acting General Counsel and Deputy General Counsel, and as Chief of Staff for a House member. He has also served in various policy and political roles at the Department of Homeland Security, the Department of Justice, and the White House Domestic Policy Council. He's a graduate of Ave Maria School of Law and Miami University. Let's give him a warm welcome. Thank you.
Thank you, everybody. It's been 18 years since I've been in a law school, so I've been a little PTSD, especially when I heard the word Blue Book. But I'm guessing a Blue Book has probably changed in that time period. Law school was when I first got my cell phone. So lots of things have changed since then. But yeah, thank you all for having me. If I'm a bit off, I apologize. I'm recovering from food poisoning. So if you're ever in Jordan and lamb tartare is on the menu, skip it. It's been 7 days and it's still but I'm for the most part better. But it's yeah. So, was the impeachment of Secretary Alejandro Mayorkas constitutional? I think the answer to that is just a very easy yes. Article 2, Section 4, the President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or high crimes and misdemeanors. Clearly, Alejandro Mayorkas falls under the definition of civil officer. So, and he was impeached. Obviously, nothing happened in the Senate. And he was charged under the auspices of high crimes and misdemeanors. So the process was all followed. It was constitutional. But I don't think that's really the question we're here for today. The question is, should he have been impeached? Did he commit a high crime or misdemeanor? Serving on the committee, we obviously found that he had done so. This was not something that came right to us. Since unfortunately the professor isn't here, I'll just change it more from an academic argument, although there's certain aspects of that in my remarks, but more into sort of more the details of how it happened. A member of Congress, Marjorie Taylor Greene, introduced a resolution to impeach the secretary that came to the floor. Instead of a vote, the Democratic minority made a motion to refer it to the Homeland Security Committee. Now, typically, virtually always, the resolutions for impeachment are referred to the Judiciary Committee. For whatever reason, that did not happen, and it came to our committee. Luckily or unluckily, I was in that office and not in the Judiciary, so I would have loved to have seen it go its normal route, and so would my wife and 4 kids, who didn't really get to see me during that time, but that's the way it is. So, the question is, what is an impeachable offense? Gerald Ford was asked this question, and so I'm guessing by some people know what his response was, is that anything that a majority of the House says it is. And while he's technically correct, because you are at the will of the majority of the majority in the House, I'm not sure that's exactly what the founders intended. Something a little bit more robust and consequential and purposeful. In most instances, impeachment has been used to remove government officers who abuse the power of the office, conduct themselves in a manner incompatible with the purpose and function of their office, or misuse the office for improper or personal gain. We've seen that throughout the history of impeachments for presidents, for judges, for now 2 secretaries. Although technically the first secretary resigned moments before the impeachment vote, so we can say that we're the only ones who have impeached a sitting secretary. So some of the arguments that have been put forth against the impeachment of Secretary Mayorkas will land on a couple of things. One, they say they'll bring back this notion of maladministration, which was one of the things over in the United Kingdom that they used to try individuals for impeachment. And maladministration included malpractice, mismanagement, incompetence, or even unpopular policies. The founding fathers thought this was a little too loose and a little too minor, so they did away with that when they were crafting the Constitution. Critics of what we did will probably say that we did charge him with maladministration as opposed to a high crime or misdemeanor. Based on my remarks, you're going to see that that's not the case. Two other critiques that you'll have heard probably is that we impeached him over policy differences or prosecutorial, or they'll hand out that Secretary Mayorkas had prosecutorial discretion to do what he did. Secretary Mayorkas was not impeached over policy differences. Impeachable offenses relate to his impeachable offenses related to actual violations of the law. Insisting on enforcing the law as written by Congress is not a policy difference. It is the fundamental requirement of the constitutional order. In Article 1 and Article 2, we laid out actual violations of law. Those are not policy differences. It just doesn't even make sense. It doesn't pass the smell test. The other argument that they make is that Secretary Mayorkas had prosecutorial discretion to do what he did in terms of who he detained, who he didn't detain, who he removed, who he didn't remove. The courts have long, we admit that Secretary Mayorkas has prosecutorial discretion. The courts have long recognized that enforcement agencies and the executive branch have the power of prosecutorial discretion. However, that prosecutorial discretion is not absolute. A line gets crossed from prosecutorial discretion to actual suspension of the law. And we believe that's what he did. You can't just claim prosecutorial discretion anytime you want to. There has to be a good rationale, and it has to be limited. That's why it's called discretion. It has to be discreet in some manner. As you'll see from what the facts all lay out, that was not what happened in this instance. In Federalist 65, Hamilton makes clear that impeachment is a political act precisely because it's not a judicial act, as in the judicial acts of punishing crimes. Rather, he writes, quote, the subjects of impeachment are those offenses which proceed from the misconduct of public men, or in other words, from the abuse or violation of some public trust. They are of a nature which may, with peculiar propriety, be denominated political, as they relate chiefly to injuries done immediately to the society itself. Hamilton writes that impeachment was, quote, designed as a method of national inquest into the conduct of public men, and that the true light in which the practice of impeachments ought to be regarded is as a bridle in the hands of a legislative body upon the executive servant of the government. So that's what we're going to be analyzing today here, is the conduct of public men. And obviously, the Republicans in the House of Representatives had policy differences with Secretary Mayorkas. That's without a doubt. But that doesn't mean that that's the grounds for which he was impeached. He was impeached because he violated the law and he breached the public trust. So then we go back to the portion of Article 2, Section 4, high crimes and misdemeanors. We often look at what does misdemeanors mean. Obviously, we know in the modern context what it means. It's a parking ticket. Obviously, that's not what we're referring to here. Professor Michael Stokes Paulson sort of spelled out what the founders meant by it. And he's relying on the Samuel Johnson dictionary, I believe, it's called a Dictionary of the English Language from 1775 that purportedly the founders used. And he said specifically the term misdemeanors in its original meaning carried with it less the sense of a smaller or less serious criminal law offense like we refer to today, and more the broader sense of misconduct or misbehavior, literally of not demeaning oneself properly, misdemeaning, in the exercise of an official capacity or position. The breadth of the constitutional language employed as the standard for impeachment thus plainly embraces a range of congressional judgment extending beyond bare criminality as to what types of culpable misconduct so amount to a betrayal of trust, responsibility, duty, or integrity as to warrant removal from office. So when we look at what we put forth in the articles, we lay out certain violations that we believe the Secretary committed. So Article 1 was entitled the willful and systemic refusal to comply with the law. And I'm going to go through just some of those briefly. He willfully refused to comply with the detention mandate, section 235B2A, requiring all applicants for admission who are not clearly and beyond a doubt entitled to be admitted shall be detained for a removal proceeding. He also willfully refused to comply with detention mandate, section 235B1B2, requiring that an alien who is placed in expedited removal proceedings and determined to have a credible fear of prosecution shall be detained for further consideration of the application for asylum. He also willfully refused to comply with detention mandate section 235B1B3. This is all of the Immigration and Nationality Act, the INA, which I'll just quote from requiring that an alien who is placed into expedited removal proceedings and determined to have a credible fear of prosecution shall be detained and removed. The emphasis on all three of these statutes is the word detained. Secretary Mayorkas did not detain in any respectable way. In each of these instances, Secretary Mayorkas implemented a catch and release scheme whereby aliens were just unlawfully released. They weren't detained. Does that mean he didn't detain anybody? No, of course not. He did. And that's where we get into the realm of prosecutorial discretion. In fiscal year 2013, when President Obama was in office, 91% of single adults and family units were detained for at least some time period while their cases were being adjudicated. 91%. And 82% were detained for the entirety of their case, which is, these cases can go on for a while. So these individuals and these family units may have been detained for at least months. Yet in FY21, this 91% figure plummeted to 36%. And just 10%, as opposed to 82%, were detained for the duration of their cases. So you go from 91 to 36, and you go from 82 to 10%. 2/3 of these individuals were never detained. 66% never detained. This is not prosecutorial discretion. This is not following the law. In fact, in January of 24, Secretary Mayorkas admitted that release rates exceeded 85%. We even had one sector chief patrol agent testify that leadership instructed them to do their best to keep detention numbers down. This, again, is not prosecutorial discretion. He also willfully refused to comply with detention mandate section 236C, requiring that a criminal alien who is inadmissible or deportable on certain criminal and terrorism-related grounds shall be taken into custody. Instead, Secretary Mayorkas issued a directive to DH officials that, quote, stating that the fact an individual is a removable non-citizen should not alone be the basis and enforcement action, should not be the basis of an enforcement action against them. Just the fact that they're removable. So we're saying, okay, he's removable, but that shouldn't be like the sole criteria. The Fifth Circuit in Texas v. Biden concluded that the directive, quote, had every indication of being a general policy that is so extreme as to amount to an abdication of statutory responsibilities, and that its replacement of Congress's statutory mandates with concerns of equity and race is extra-legal and plainly outside the bounds of power conferred by the INA, the Immigration and Nationality Act. Putting it to numbers, as of the first quarter of fiscal year 23, there were 408,000 convicted criminal aliens on the non-detainer list. So they were in the country, non-detained. Those individuals that they knew to have had criminal convictions before they were released into the interior of the United States. That was 408 by first quarter fiscal year 23. By January 24, that number grew to 617,000. Again, not prosecutorial discretion. Secretary Mayorkas also willfully refused to comply with detention mandate section 241A2, requiring that an alien ordered removed shall be detained during the removal period. In that same directive that I mentioned earlier, Secretary Mayorkas told DH officials, again, that the fact an individual is a removable citizen should not alone be the basis of an enforcement action against them. Moving out of the detention realm, I think we've handled that quite thoroughly. He also willfully exceeded his parole authority, set forth in 212 D5A, that permits parole to be granted, quote, only on a case-by-case basis, temporarily, and for urgent humanitarian reasons or significant public benefit. So, parole. What's parole? It's not what we think of when somebody's released from jail and is let out on good behavior, but they have to check in with a parole officer or whatever. Parole is when an individual is still inadmissible non-citizen, but is released into the interior of the United States for a certain period of time and for a distinct reason. So there's urgent humanitarian reason and significant public benefit. It has always been traditionally understood for purposes of parole that urgent humanitarian reasons are medical reasons, and a medical emergency. Obviously, in Mexico, in the Northern Triangle, they don't have the doctors that we have here. And so individuals have been allowed to be paroled into the United States for that. And the other option is a significant public benefit. That has always been traditionally understood for purposes of parole to be witness in a criminal case. So these are the reasons, and it can only be, on a case-by-case basis. You. It has to be temporary. Once your medical procedure has been performed, you have healed properly, you must remove yourself. In the significant public benefit, you go, you testify in the case, you remove yourself. That's how parole traditionally has worked. This is not what has happened under Secretary Mayorkas' realm. He's paroled aliens en masse. And they've used the excuse of urgent humanitarian reasons for wide swaths for thousands and millions of people. Oh, we can't detain them, so we have to release them all. Obviously, that's not case by case. It certainly hasn't been temporarily. And it's supposed to be for the humanitarian reasons of the individual, not for DHS's inability to detain them and overcrowding issues. This led the Fifth Circuit to conclude that, quote, ignoring the limitations Congress imposed on the parole power is not non-enforcement, it's misenforcement. Suspension of the INA, or both. On top of this, Secretary Mayorkas created, reopened, or expanded a series of categorical parole programs never authorized by Congress. DACA is one of those that I'm sure you've all heard of that was around during the Obama administration. So these parole programs create categories of individuals to come in to the country under this parole authority. These programs have to be created by Congress. Secretary Mayorkas didn't do that. He created them himself. So that sort of encapsulates Article 1. Then, however, in 2023, the case Texas v. Biden came out. And it's just very interesting that it came out right prior to all the issues we are having. The Supreme Court heard a case involving Secretary Mayorkas and his refusal to comply with certain federal immigration laws that I just discussed with you. The court ruled that the states have no standing to seek judicial relief to compel Secretary Mayorkas to comply with these requirements of the INA. They didn't rule on the merits. They specifically said you have no standing. So where can they go for remedy? Well, Congress. They said, in the alternative, the court concluded that other forums remain open and that Congress possesses an array of tools. And Justice Kavanaugh's questioning to the Solicitor General, who Justice Kavanaugh wrote the majority opinion in this case, questioned her on the outlets for remedy. If we conclude that we don't have standing, what is someone supposed to do? Because obviously the states have injuries. It's without a doubt, and the individuals within the states have injuries. So where do we go for recourse? And the implication that he got from her response was that you can either shut down the government or impeach the individual. She didn't say that specifically, but that's what he took from her response. So this is what was presented before us when we were crafting the articles, is that here we are accusing a sitting secretary of refusing to comply with the laws. The Supreme Court has just told us that the states don't have standing. So what else are we to do? Well, the Congress has different tools that it can use. One, it can write legislation. Well, Secretary Mayorkas already isn't following the law, so I'm not sure that passing new laws is going to have any effect. Appropriations. We have the power of the purse. We can refuse funding or lessen funding. But then we provide him an excuse that he can't detain anybody because he doesn't have the appropriate funds to do so. So that's not going to get us anywhere. And in fact, not only Secretary Mayorkas shut down detention facilities. There's one facility in California that can hold 2,000 people. At the time there was 11 people there, and just thousands upon thousands of other facilities had beds just unfilled. So he wasn't trying to fill them. On top of that, every year, secretaries come in and ask Congress for money, and they tell them what they want money for. He asked for a reduction of funds for bed space, so they could have less beds. But he's claiming that he has to release all these people into the interior because they're overwhelmed. Well, of course, because you're not detaining them anyway, which led Judge Weatherall down in Florida, the district judge, to say, this reminds me of a boy who's killed his parents and then seeks sympathy because he's an orphan. So this is what we're dealing with. Again, not prosecutorial discretion. Certainly not policy differences. Article 2, the breach of the public trust. Secretary Mayorkas knowingly made false statements under oath and obstructed lawful oversight. Many times he came before our committee, Judiciary Committee, a couple of committees over in the Senate, and under oath told us the border is secure. The border is closed. Now there's also something called the Secure Fence Act, which mandates that the Secretary, the DHS, has to have operational control of the border. And the way it's written, it basically says that if anyone gets into the interior without being detected or is released, that you don't have operational control. So that obviously means that you can never have operational control. No secretary prior to Secretary Mayorkas, when this law was written, has said they had operational control. The law is aspirational, as it's written. It's not meant to say you're violating the law because 3 people got into the interior and therefore you have to be impeached. That's not what we're saying here. He's the one who came before the committee and said, by the definition of operational control, he has it. So he repeatedly lied to Congress, and lying to a member of Congress, big deal. Going on Fox News, CNN, MSNBC, saying the border is secure, whatever. This is under oath, and this is to the American people. Say in the year 1910, when we didn't have televisions, that we can't see the mass flood of people coming into our country. We don't know that there's a border crisis, so we rely on the bits of information we get through newspapers or whatnot. And if the Secretary of Homeland Security back in 1910, obviously it didn't exist then we didn't have a department, said that the border's closed, the border's secure, the American people are going to believe it. So that's a huge breach of the public trust. We don't see it as a public trust necessarily now because we know he's lying. So we're not as offended by what he's saying because we just obviously know it's not true. But that doesn't matter. He's still a civil official who is lying under oath. He also breached the public trust by his willful refusal to fulfill his statutory duty, quote, to control and guard the boundaries and borders of the United States against the illegal entry of aliens, end quote, as set forth in Section 103E5 of the INA. So he has the duty to control and guard the boundaries and borders of the United States against illegal aliens. In his term over the last 4 years, he has terminated the migrant protection protocols. He's terminated contracts for border wall construction. He's terminated the asylum cooperative agreements that we've had with other countries. These 3 things that no one would argue has led to greater control of the border. Was he within his authority to terminate all of these? He was. So where's our complaint? If he's allowed to get rid of these things, why am I bringing this up? Well, it's not that he didn't have the authority to do that, it's that he didn't replace them with anything. He has the duty to control and guard the boundaries of the United States. If there's all these other laws you're already not enforcing, and then you take these programs, the migrant protection protocols, the border wall construction, asylum cooperative agreements, you take those all away, what else do you have left? So he's clearly not fulfilling his statutory duty to control and guard the border. It would be like a sheriff walking in to the quarters, the prisons of the jail, and unlocking all the doors, leaving the doors closed, but unlocking all the doors, and then saying, well, what else am I supposed to do to keep them in? I mean, what other responsibilities do I have? They're in their cell, the door's closed, I just unlocked it, but how am I supposed to presume that they're just going to walk out? So he's taken out he's removed the teeth of enforcement. And so we're saying that is a breach of the public trust. So not only when we look at impeachment for high crimes and misdemeanors do we just look at the offenses themselves, we look at the effects. We all see what the effects are. High amounts of fentanyl have flooded into the country, killing hundreds of thousands of people. Crime is rampant. People are being murdered. Assaults are occurring everywhere. We see them all over the news. I don't have to tell you the effects that this has had on our country. They're devastating. So to say that, again, that this is all down to policy differences is just ludicrous. And we see that by the numbers. When we talk about encounters at the borders and gotaways. So what are gotaways? Gotaways are people who there's 2 types of gotaways. There's known gotaways and there's unknown gotaways. So a known gotaway is the patrol agent's detaining somebody and he sees 5 people going across and can't stop them. They'll count those. Those are known gotaways. Obviously the unknown gotaways are the people he doesn't see. So all encounters at the borders And these figures I'm going to give you include all the counters and also the gotaways and the known gotaways. So how do you find a number for non-gotaways, unknown gotaways? President Biden's border patrol chief told us you basically add 20%. So in President Obama's last 4 years, if you count all encounters and all gotaways, known and unknown, it comes to about 3 to 3.5 million people. Under President Trump, if you include the encounters at the borders, gotaways, also 3 to 3.5 million people. Under President Biden's Secretary Mayorkas, 13 million. He goes from 3 to 3.5 to 13 million people. This isn't over policy differences. And it just doesn't happen because, for some reason, more people came in under this administration. They came in for a reason, because they knew that nothing was going to happen to them. This is intentional non-enforcement. And it's a significant violation of the separation of powers. That's all there is to it. There it goes.
Thank you so much for coming to speak to us.
Sure.
Our previous panelists kind of discussed the history of impeachment, both presidents and other sitting figures, and kind of argued that the public and the political perception of impeachment has changed over time and has lost some of its gravity and is now being seen as just another tool in the political arsenal. Would you agree with that? Would you agree that the perception of impeachment process has changed? And if so, do you think that's a good thing or a bad thing or neutral?
I mean, I would say the process hasn't changed, especially as we just have a more divided country. And I mean, when did we become so divided? I mean, it's going to happen. It's happened throughout history. I mean, it probably happened when the Judge Bork nomination came about. That's when you saw real division in the House and the Senate begin. And it's just sort of spiraled out of control. And it's just getting worse. And do I think that there are Republicans in the House who could have cared less about the specific things we laid out in the articles and just can't stand Secretary Mayorkas and voted to impeach him? Of course. Just how I know that there are Democrats who knew he violated these things, but he's a member of their party, so they voted against impeachment. I mean, that's what we see time after time in impeachments. I don't think you even have to go to start with the nomination of Judge Bork. You can go back before, where impeachments are just partisan. That's all there is to it. And it's because it's only with something egregious, say like with President Nixon, that you see that obviously he resigned before that, but that's because Republican members of the Congress came to him and said, "Sir, you're going to be impeached," and that's why he resigned. There were plenty of votes on both sides. So on egregious matters, I think you see this uniting, but when it's not something as obvious as as what he did, and to the American people, I mean, everything we just laid out. I mean, this stuff isn't in the news. I mean, you see the pictures of people flooding across the border. You hear about crimes and whatnot, but you don't see, obviously, Brett Baer and Dana Bash aren't talking about provisions of the INA. So that's sort of us to bring to the front.
Do you think, the partisan nature of impeachment, do you think that's actually more of a feature rather than a bug of the impeachment process? So I think that one of the rationales for both sides of the aisle, impeachment of Trump and your impeachment of Mayorkas was to bring attention to his crimes, his lies, his perjuries. And was that kind of your number one rationale for bringing that impeachment in the first place, not to remove him from office necessarily?
I'm not sure. What should I understand the question?
Did you even though you knew that the goal was not, or did you know that the goal was not to remove him from office, right? Did you think that was a possibility? If not, what's the rationale to just bring to light a lot of his crimes.
Yeah, I mean, we knew the Senate wasn't going to do anything.
Right.
We at least thought they'd have a trial. This is the first time that's in like 27 instances of impeachment of either presidents, federal judges, or secretaries. This is the first time there hasn't been a trial. Chuck Schumer just did away with it because he knew he could get away with it. He didn't want all this out in the press, and so he's like, let's just get rid of it, and probably no one will we'll get some bad publicity for a week or so. So we knew nothing was going to happen. We knew we wouldn't get, just like with the Trump impeachments, everybody knew that the Senate was not going to convict him. But that doesn't but because of that, we just don't not do anything. Can you say it's partly messaging? As Brady's laughing because he's worked on the Hill. There's you do things because you want the desired outcome, but then also there's other instances where you want that desired outcome. It's not going to happen, so you do it for messaging. That's the code word. So was there some messaging? Of course there was, but it was also holding him to account. He now has this stain on his record for the things he's done, and it's warranted. We didn't bring impeachment. I say we. I shouldn't say we. I was so involved in the process, I invariably use that term. The members of Congress did not impeach Secretary Mayorkas. He brought this upon himself.
Yeah, I think with that, thank you so much for speaking. This has been really great. Sort of after the impeachment, sort of what has been the aftermath for you folks on the committee, for the Congress, and for relations with DHS? Sort of what have you seen come out of, because for the first time since the 1800s, doing this, what's been the effect writ large?
The minority in the committee, they're slowly getting over it. There was certainly tension for a while. The markup itself was extremely combative and extremely long. It started at 10 o'clock in the morning and ended around 1:30 in the morning because they just brought amendment after amendment after amendment. And as the amendments came, they lessened in their quality. I mean, they were all like, strike Article 1, strike Article 2, change it this. Nothing that we would have, that the members in the majority were going to allow. But then they started engaging in the amendments were engaging like personal attacks. And one thing you don't really want to do in a markup like this is shut down the amendment process. You want to see it to its end. But the amendments got so derogatory that we warned them. We told them, okay, you've had a couple amendments that were just terrible. If you do this again, we're going to call the question in debate. And they did it again. And so a member on the committee, we told him, call the question. And like the parliamentarian for the Democrats, like his head like almost exploded because we did that because he wasn't expecting. It's like we just warned you that this would happen. So suffice it to say, tensions were high with the committee for quite a while, but now they're just going. It's never been good, but now it's gotten back to normal. Yeah.
I think sort of with that, what do you see as the sort of long run precedent from the Senate Democrats not doing the trial? Kind of how do you see that affecting sort of future?
I mean, unfortunately, it's only time will tell. I mean, it's not good that they've done this. It's probably going to be circumstantial. It's going to have to depend on the party, the numbers, what the accusations are, where the American people are on this. I think it's all going to just depend on those factors. I'm not sure we're able to predict. I mean, in the end, I don't think the dismissal will have a large impact because, again, it's all about messaging. But it will certainly give them fodder for either party to do it. One, because they'd already done it, and because there wasn't a backlash when they did it. There wasn't a public outcry that they dismissed it. So I can certainly see it happening again, but whether that'll happen, time will tell. Yeah.
Any closing words? If not, we're all good.
I don't know. Thank you guys all for coming. I was present on my FedSoc chapter when I was in law school. So I appreciate all that you guys are doing to keep keep the movement going on. You know, you guys, I'm sure a lot of you know Peter Redpath, known for many years, both on the student side and the. Well, actually, he was head of the chapter. I mean, I graduated from law school 18 years ago, and years before I started, he was running the student chapters. So I knew him when he was in that capacity, and I was just a student. Now, of course, we know each other, you know, as colleagues. So, yeah, definitely. Any words of advice? Just get to know Peter Redpath. He's a great guy, and obviously he's obviously a great resource. But yeah, thank you for all you guys are doing. Keep this going.
Thank you.
For getting me out of the office.
We do have lunch. We're gonna get going if you would like some.
Sure.
So.